So the marital home is treated like any other asset from a standpoint of valuing it, from a standpoint of classifying it. However, the difference with the marital home is we have the issue of occupancy. So there are times that even though it's a marital asset and we may value it, we may not distribute it in the divorce proceeding. We may decide that the value will be divided up later, and one of the parties may get exclusive occupancy in the marital residence. Typically, where we see that is when there are young children. So if there are children, if they're 13, 14, it's not uncommon, if the finances permit it, that the spouse that has primary physical custody will remain in the house. When we have investment accounts, stocks, bonds, similar, the way those get divided is sometimes we will just divide them in kind. So we'll split the account. So if there's 100 shares of Apple stock, each party will get 50 shares. Other times we'll come up with a value. We have to be really careful with that. A lot of times we've seen where people don't realize that there are capital gains, there are losses that all have to be considered when we're dividing those accounts. With retirement accounts and pensions in New York, the one time that we can divide them is with a divorce. So if somebody has what we call a defined benefits plan, if they've worked for, we see it less and less in the private industry, but we still see it a lot with people that work for government. They'll have a defined benefit plan. They'll have a pension that will pay them out monthly for the rest of their lives. We can actually split that in a divorce in New York State. It requires a separate order, but it's something that we do very commonly and very frequently. When people come to us and they own a business, so they have a professional practice, doctor, lawyer, whatever it may be, those do get valued. We do bring in outside experts to do that. It requires a great deal of discovery to really get a handle on the history of the business, the revenue, the profit. We dig deep, and then we're able to come up with a valuation of those things. After we value a business or a professional practice, the value will get divided. It's typically not 50-50. That's really the one asset where we most commonly see an exception to that. And then we're really looking at the contributions of the other spouse, and really even both spouses. How has the business grown, and what did the other spouse do to contribute to the growth in the value of the business, whether it's direct or indirect? So real estate holdings and investment properties, second homes, commercial properties that people have, those we also value, and they also get divided. Sometimes they need to get sold. Other times, if there's significant assets, significant wealth where we can offset it, sometimes one party will keep those investments and the other party will receive their share of the fair market value. So personal property, family heirlooms, those are things that are really treated like any other asset in a divorce, except when we mention family heirlooms, if we can show that that is something that was gifted or inherited by one party, that's their separate property and it remains theirs. Personal property, we often will not get into the weeds on. It's often not worth it. Unfortunately, most of the things that we buy don't have high resale value, but some things do. When we have clients that have significant investments in art, in jewelry, those are things that we can value, and that makes sense to value. So debts and liabilities also get divided. The goal, of course, is to pay them off as part of the divorce proceeding when appropriate. You wouldn't do that with a mortgage generally. So they're really treated just like assets. And we're looking at the total net worth of parties when we figure out how to equitably divide those things. So when businesses have debts, if the debt is in the name of the business, that's going to be part of the valuation process on that business. So the party that's taking the business will also be taking that debt. Cryptocurrency, like any other asset, and something that we're seeing more and more of these days, gets divided. So if it was accumulated during the marriage, we're valuing it and we're dividing it, or we're just splitting the account when appropriate. When we have clients that have intellectual property, royalties, whether they were an author or a musician, there's a future stream of income that comes with that, and we're valuing that future stream of income in deciding how do we equitably divide it? How do we make sure that the spouse that doesn't hold those rights is fairly compensated?